All right, we're on the record in 23-00398. That is people of the state of Michigan versus Deshaun Tawan Reed. Will the parties please introduce themselves for the record?
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Your Honor, Dale Colter here on behalf of Mr. Reed.
How are you, Mr. Colwrighter?
I'm fine. Thank you.
This is the time set for a preliminary examination today. It's my understanding, and correct me if I'm wrong, that we received notice that Mr. Reed was not brought over from the Ingham County Jail because he was on suicide watch. Is that everybody's understanding?
Yes, the court emailed me that earlier this morning.
All right. So, Mr. Pfeiffer and Mr. Colwrighter, how would you like to proceed today?
Well, Your Honor, the people were prepared to proceed today, or witnesses appeared today, but obviously we cannot hold the preliminary examination without the defendant.
Right.
I would ask that this be adjourned, and I'd ask that good cause be found for a waiver of the 21-day requirement for that examination.
All right, Mr. Colwrighter.
Your Honor, I'm not going to argue against it. I need my client here to hold the preliminary examination.
Right.
I would indicate to the court, based on my discussions with him, today's developments, and actually just reading some of the discovery, I'll probably maybe have him sent to forensics.
Okay. All right. So we'll wait for that decision to be made, but I mean, that's an understandable request now that this has occurred. I have that he has not waived his right to a 21 days, so we will indicate that this is adjourned for good cause. For good cause, as defendant was not brought over and is on suicide watch. And then we'll get a new date in the interim just to have it as a control date. A new date.
1 or 3 weeks.
Mr. Colwrighter, probably 3 weeks would be better than 1, I would think, in order to do the paperwork on this. So 3.
March 17th at 9 a.m.
March 17th at 9 a.m. for the adjourned preliminary examination. And then go ahead.
That works for the people.
Mr. Colwrighter, does that work for you?
Your Honor, thank you.
All right, and in the interim, you can let us know what's going on with the competency review.
I will, Your Honor.
All right. Anything else for the record? Docket 23-00398, Mr. Pfeiffer.
Not from the people, Your
Mr.
Honor.
Colwrighter.
No, Your Honor.
All right, thank you for your points.
Thank you, Your Honor.
We'll go that email too. Just to remind us. I can read my right. And Ms. Robbins. Right. Right.
Yeah, I believe it's Mr. Dumont.
All right, I'm gonna call Mr. Dumont. Are you ready on him, ma'am?
Yes, Your Honor.
What's your name, ma'am?
Jessica Shaw.
Jessica Shaw. All right, Ms. Shaw. I don't think I've had the pleasure of meeting you, so
Nice to
welcome.
meet you. Thank you.
All right, we're on the record in docket 22-03439. That's people of the state of Michigan versus Franklin Dumont. Will the parties please introduce themselves for the record?
Jessica Shaw on behalf of the people.
Erin Robinson, Assistant Public Defender for Mr. Dumont.
And sir, you are Franklin Dumont?
Yes, Your Honor.
Okay, and you can hear me all right, Mr. Dumont?
Yeah.
All right, Ms. Shaw, this is the time set for preliminary examination today. How are we proceeding?
Your Honor, it is my understanding that both parties unconditionally waive the right to have a preliminary examination and ask that the matter be bound over to circuit court as charged.
And Ms. Robinson, is that your understanding today?
It is, Your Honor.
All right. And one of the purposes for Mr. Dumont being on Zoom, as indicated, was that the original was the threat of COVID or being are having COVID-like symptoms. Is that correct, Ms. Shaw?
Yes, Your Honor.
Ms. Robinson?
Yes, Your Honor, he was exposed to COVID and is awaiting test results.
All right, so Ms. Robinson, your client has does not have any objection to the waiver proceeding by Zoom?
He does not.
All right. May I inquire of your client of his waiver of his preliminary examination?
You may.
All right, Mr. Dumont, you understand you have the right to a preliminary examination in district court on this file. Do you understand that?
Yes, Your Honor.
Okay, and a preliminary examination is a probable cause examination in which the people of the state of Michigan would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You, of course, would be represented by Public Defender Erin Robinson. She would cross-examine any witnesses brought by the state or contest any charges brought against you. Is that your understanding, sir?
Yes, Your Honor.
It's my understanding today that you wish to unconditionally waive your right to a preliminary examination in district court and have negotiations continue in circuit court. Is that correct, sir?
Yes, Your Honor.
All right. Ms. Shaw, is the prosecutor also waiving their right to preliminary examination?
Yes, Your Honor.
All right. So the defendant has waived his right to a preliminary examination in district court. Prosecutors also waived their right. I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. I'll bind this case over as charged with negotiations to continue. Is that correct, Ms. Shaw?
Yes, Your Honor.
It is, Your Honor.
Thank you, Ms. Robinson. So, Mr. Dumont, your time in district court is done. You've been bound over to circuit court with that, that means that you are in circuit court for that trial jurisdiction. Please keep in contact with your attorney, Erin Robinson, for any future dates. You'll get them from the public defender, okay?
Yes, sir.
Okay. Ms. Shaw, anything else for the record, docket 22-03-439, or did I forget anything?
No, Your Honor.
Okay. Ms. Robinson?
No, Your Honor, thank you.
All right, Mr. Dumont, you're all set. You're going to be in circuit court to get your next date, all right?
Yes, Your Honor.
All right. That's all for the record, 22-03-439. Thank everybody for their appearance.
Thank you.
Can't sign this, right? But I can. Not on this one. I think it depends on the form, right?
Yes.
People of the State of Michigan versus Isaiah Hooper. Will the parties please introduce themselves for the record?
Jessica Shaw on behalf of the people.
And good morning, Your Honor. Stephen Mills on behalf of Mr. Hooper, who is present and standing to my right.
Sir, you are Isaiah Hooper?
Yes.
All right. This is the time set for a preliminary examination and a PA 53 contempt violation. Ms. Shaw, how are we proceeding?
Your Honor, with regard to the preliminary examination, the victim has failed to appear and the people are unable to proceed without the victim.
All right, Mr. Milks?
Yes, Your Honor. This time we would like to move for dismissal of this case.
That's supposed to dismiss. Can I imagine that's a dismissal without prejudice?
Correct, Your Honor.
All right, so in regards to, and I would assume that also, well, we'll talk about the PA 53 when we talk about it, but that also applies to PA 53.
Your Honor, the PA 53 is we do have the officer here for that. It was one of those tether violations, so potentially we could proceed on it, but I'll leave it to the court on that.
All right. Well, let's deal with the prelim first and what we'll do with the PA 53, which is a condition of bond on the case. Mr. Milks, is your understanding that the victims failed to appear and you're moving to dismiss without prejudice?
That is correct, Your Honor. Yes, as the defense is ready to proceed today and people being unable to, we would move for dismissal.
So, Mr. Hooper, you understand that people are unable to proceed today. So this case is going to be dismissed without prejudice, which means that the people may reissue if they choose to, but for our purposes today, the case is dismissed. Do you understand that?
Yes.
All right. And we'll, once my court officer gets here, we'll be able to sign a nollie to that effect, okay?
I did it this morning.
Thanks, sir.
I did
What's
a
that?
record on that. If that's- sorry.
People move, defense moves. Yeah,
I did
that's
record
fine.
it.
That's
Okay.
fine. Yeah.
Yeah, it's on the printer, Mr. Milks.
Yeah.
I'd like
So,
to
Mr.
grab
Milks, you
that.
can get it. It's on the printer.
Sir.
All right, and then we can make a copy of this. Let's go for it. Let's go on the PA 53. That's a violation. The Ms. Shaw from the prosecutor's office indicated that's in the court's discretion. Mr. Milks, what's your position on that? We do have an officer here concerning that PA 53 violation.
Your Honor, at this time, if I may have a brief moment with my client, Your Honor, I
Okay.
apologize. Sorry, thank you very much, Your Honor.
You may proceed.
Your Honor, it's my understanding, we would like to, we'll admit to the violation, Your Honor. He does have an explanation at this time that he'd like to provide to the court.
All right. So is that your understanding, Mr. Hooper? In regards, you have the right to a hearing. You have Mr. Milks here. You're right to contest any charges concerning this PA 53 violation. It's my understanding you want to waive those rights and admit to the violation, explain the violation to the court. Is that your understanding, sir? Is that a yes?
Yes.
Okay. All right. So I'm going to raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Your other right hand. Tell the truth, the whole truth, and nothing but the truth under penalty of perjury. Is that a yes, sir? Okay, you got to speak up because we got to record you, okay?
Yes, Your Honor.
All right. It's my understanding that there was a no contact order in regards to a tether. And then you were wearing a tether at the time of this incident. That incident would be, which occurred on, and if I've got the paperwork correctly, it happened on February 6, 2023 in the city of Lansing at Willow Street. Were you there were you there in the city of Lansing on Willow Street on February 6, 2023?
Yes, Your Honor.
And were you in violation of your tether on that date?
Was it beeping?
Yes, Your Honor.
Okay. And you knew it was beeping?
Yeah, when I made it to the area.
Okay. So if it's beeping, you would be in violation of the tether? Is that a yes, sir? Okay. All right. Now tell me about what happened.
So the victim that was there, she moved in with her mom. And when I walked all the way from the south side all the way to Willow. So I walked up to my brother's apartment because my brother lived like right next door from my apartment. So when I walked into my brother's apartment, the tether started going off, but the victim was nowhere around. She was gone. I can't tell you how many days.
Right.
It was she left the area. It was just because her name was still on the house.
Right.
It was still like her.
You'd agree with me that it's probably a bad idea once the tether starts going off to be anywhere where the victim may have been in the past.
You should speak up.
Yes. Your
Yeah. I mean, I understand you're indicating I wasn't in the presence, but of the victim, but the people who run the GPS just have an address, and you were in the zone of the exclusion. So to them, you're violating your probation. You're violating a no contact order. So if you have a problem with the address, you probably should talk to somebody before you go and you're in the inclusion zone. Go ahead, sir.
Your Honor, before they let me out on tether, I told the tether people, I wrote down the address on the paper, and I told my parents to tell the tether people, and they still marked that spot as the red zone.
Okay. So if it's marked on the red zone, it's probably a good idea to stay out of there until this is all fixed, right?
Yeah, they have misunderstandings.
It is, but who's the one who suffers for the misunderstanding? Yeah, you do. Yeah, you suffer for the misunderstanding. I mean, that's the nature of it. So you have to make sure there's no misunderstanding, right? I mean, if anybody's going to get picked up, it's not the tether people, it's you, right?
Yes, sir.
So once the tether starts going off, it's probably a good idea to get out of the tether zone, right?
Yes, sir.
All right. I'm gonna Ms. Shaw, anything on this?
No, Your Honor.
All right. I'm gonna treat this as a learning point. Okay. This is a learning point. You're the one who suffers for this. I mean, you've got to come in front of me. We've got to work this all out. You know, there won't be a next time, right? But you should tell people, look, if the tether goes off, you probably need to leave someplace or get out because you're the one who suffers. I'm right.
Yes, sir.
All right. I find the admission of the PA 53 violation to be knowing, voluntarily, and accurately made. I think this discussion we've had hopefully will be fruitful, that we'll learn from it.
Yes,
And so I'm going to indicate that the admission is that to the violation of the exclusion to the exclusion zone has been admitted, but I'm going to dismiss the case after that.
Thank you, Your Honor.
So admission to the PA 53. Court indicated warning and dismissed. It always makes me laugh a little bit, Mr. Hooper. I'm only saying this because I've heard it. When people are crossing a red light and they're in danger of getting hit by a car. And they always say something like, well, I'll sue him if I get hit by the car. Well, that doesn't help your loved ones, and that doesn't help you in a hospital room with, so yes, you can sue, but the ultimate person who pays for crossing the street is you, right?
Yes, sir.
So I just take it as a learning point, okay? Yeah, you want to protect yourself from this kind of stuff, right?
Yes, sir.
All right, anything else for the record in docket 2300248 concerning the PA 53, Ms. Shaw?
No, Your Honor.
Mr. Milk?
No, thank you,
All
sir.
right, thank you. Mr. Hooper, good luck to you, okay?
Thank you.
Thank you.
And then I think we have Mr. Mr. Bossy. All right. All right, we're on the record in docket 2202734. That's David James Bossy. People of the state of Michigan versus David James Bossy. Will the parties please introduce themselves for the record?
Jessica Shaw, on behalf of the people.
May it please the court, David B. Carter Jr. on behalf of Mr. Bazzi, who is incarcerated and standing at council table.
Thank you. And you are David Bossy, sir?
Yes, Your Honor.
All right. This is the time set for a preliminary examination. Ms. Shaw, how are we proceeding today?
Your Honor, it is my understanding that Mr. Sarts was the defense attorney in this matter. However, Mr. Carter was recently appointed as conflict counsel, and so they would be asking for an adjournment in this matter, and the people have no objection to that.
All right, Mr. Carter?
Thank you, Your Honor. Your Honor, as Ms. Shaw indicated, I was contacted by the public defender's office yesterday, asked if I would take on this case, which I indicated I would. I did file my appearance today with a substitution of counsel for your honor to sign. I had a very brief moment talking with my client. I have not been able to talk to him until today. His desire to have a preliminary exam is very strong. He believes he's innocent in these charges, but however, me being newly on the case without having a police report, I'd ask the court to find good cause to waive the 21-day rule and set it for a date and time in which I'd be more fully prepared to represent Mr. Bossy.
All right. So because of new counsel, may I inquire of your client?
Sure.
It's my understanding, sir, that Mr. Carter has just gotten on the case, that we do plan on having a preliminary examination in the matter. I've signed the order of substitution for Mr. Carter in regards to Mr. Sarts. Mr. Sarts is now waving at me. He's no longer involved in this case. But in order to do that, in order to get Mr. Carter up to speed with discovery and police reports and to know a little bit about the case, we need to adjourn the preliminary examination today. Do you understand that, sir?
Yes, Your Honor.
You have a right to a preliminary examination within 21 days. I'm going to find that there's good cause because of the new appearance of counsel. So you don't have to waive your right to a prelim within 21 days, and you don't have to waive your right to a prelim at all. We're just going to find a good cause to waive this initial prelim within the 21-day period so that Mr. Carter has some time to look at discovery, look at police reports, and then talk to the prosecutor in the case. All right, sir?
Your Honor.
All right, so all parties, I will indicate all parties appeared. Attorney is brand new conflict counsel. I find good cause to adjourn. At this time, there's no waiver of 21-day. And we'll get a new date and make sure that it's good with your schedule, Mr. Carter.
March 17th at 9:30.
Would March 17th at 9:30 work for you?
I can make that work, Your Honor.
All right, so March 17th at 9:30 is the good cause adjournment preliminary examination date.
My client did want me to address bond.
All right.
I did have an opportunity to look at the Register of Actions yesterday when the case was forwarded to me. So part of my due diligence was to look at bond. I do understand that bond appears to be reasonable regarding these types of charges. However, I haven't seen a police report. My client's concern is that he has another charge out in Eaton County that he's fearful that he will not get time credited while he's here. He asked me to ask the court for a PR bond so he could go take care of that.
I can-
Asking for a PR bond causes some concern because then he wouldn't start getting credit here.
Right.
So I would leave that to the court's discretion. If the court denies bond, I will contact Eaton County and try to get him arraigned out there at
Right.
ASAP.
Well, here's Ms. Shaw.
Yeah, people would object to that. He's facing a life offense here.
Yeah, I mean, if I'm gonna do, if he's incarcerated on this, he should be getting day for day credit from the other court, I would think. So there's a second reason for me. Not only are the charges quite extensive in this case, and I think I think this is a reasonable bond set by, I believe this was Judge Simmons. But the only thing I would be left if he can't make bond is to make sure he's getting day for day credit concerning his incarceration here, which with counsel on your side, that's part of the responsibility. So I'm going to deny the motion to reduce bond. I think the bond is for this time. We can revisit it on March 17th if needed. But I'm going to deny the motion to reduce bond as being reasonable concerning the charges. And also, you want to make sure you're getting credit for any time involved here in Eaton County also, okay? Anything else for the record in docket 2202734, Ms. Shaw?
No, Your Honor.
Anything, Mr. Carter?
No, Your Honor.
Thank you. All right, we'll see you on the 17th, sir.
Thank you, Your Honor.
Okay, I'll contact- I'll try to-
Let's David Dupre.
I think they want to leave a date.
Dates.
If I need to know, we have to see it.
Mr. Blackman, how are you? As always, as always.
Your Honor, we're
Thank
also-
you, Your Honor.
We're
Thank
also
you, Mr.
ready on Nanette Helmick and David George.
All right.
Mr. George is a guest.
So,
He in the thing already went to get some.
all right. The helmet, the net helmet.
We have not got Mr. Blackman's appearance.
All right. All right, we're on the record in docket 23-00307. People of the state of Michigan versus Nanette Marie Helmick. Will the parties please introduce themselves for the record?
Thank you, Your Honor. Jessica Shaw on behalf of the people.
Your Honor, Fred Blackman, standing in with Ms. Helmick today.
All right. And ma'am, you are Nanette Helmick.
Yes, sir.
All right. This is the time set for preliminary examination on the matter. I know that Mr. Blackman's name was brought up last time. And so we left it on for the preliminary examination. Ms. Shaw, how are we proceeding today?
Your Honor, it is my understanding that Mr. Blackman will be taking this case, but does not have any information yet. And so he will be asking for an adjournment and the people have no objection to that.
All right. Is that your understanding, Mr. Blackman?
I haven't been retained yet, but I talked with Ms. Helmick this
Yes, I
morning, and she said that she's going to retain me. So I talked to her about a 21-day rule.
Okay.
She needs to waive that to adjourn it, and I'll notify the court immediately when I get retained. But she just, when I told her about it and she walked by me, I'm retaining you, so.
We're doing that.
All right. Well, we're glad we've gotten this far. All right.
Yeah, me too.
All right. But Mr. Blackman is right. This day is set for preliminary examination. You have a right to a preliminary examination within 21 days of your date of arraignment. Do you understand that?
Yeah.
If you waive that right within the 21-day period, we'll just be adjourning outside of that 21-day period.
That's fine.
Really, that's to get Mr. Blackman on, to get his appearance and get him all discovery in the case, so
Okay.
that he can look at it and review it as a lawyer.
Yeah.
So it's my understanding, so in a preliminary examination, why we're all here is a probable cause hearing in which the people of the state of Michigan would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You understand that?
Yep.
You're gonna retain Mr. Blackman, that's in theory, and
Yeah.
Mr. Blackman would contest any charges or cross-examine any witnesses brought in your defense. You understand that?
Yes.
And brought by the people.
Yeah.
All right, is it your way, it is your wish today to waive your right to a preliminary examination only within that 21-day period so that Mr. Blackman can involve, and then we'll reset the preliminary examination outside of that? We're still gonna have a prelim.
Yeah.
Is it your intent to waive your right to a prelim within 21 days?
Yes, sir. it is.
Yeah, I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made. And we'll reset a preliminary examination date that fits within your busy schedule. So,
If the court just said,
Think
Hang
about
on,
it. Think about it. Think
yeah,
about
you,
it.
you,
Wait a minute.
so let's do, so D waive the right to 21 day. And Ms. Shaw, the people also waive the right to a 21-day rule,
Yes, Your Honor.
prelim within 21 days.
Yes, Your Honor.
We'll reset for
Judge, it's either, how about March 2nd or the 16th?
March 2nd or the 16th.
The
Oh,
16th
actually, March 2nd.
is definitely not, we're running a murder exam that day. March 2nd, we can do in the afternoon, and sometimes that does not work for Mr. Blackman's schedule.
I can't do it in the afternoon on that day. How about the 16th, Judge? I have nothing.
Got a murder prelim that day.
Okay.
It's going. We set it aside for a murder prelim.
Oh, did you? Okay.
Yeah,
I can
Not
do
in that
March
one.
17th at 1:30.
March 17th.
Yes,
All right,
At 1:30?
yes.
we'll do March 17th at 1:30. And the only reason we have the murder is because we put it on that day, so to have its own
Yeah,
day.
no, I understand why I'm in the middle of a
Right.
torture thing with Judge Allen.
So let's set it for March 17th at 1:30. Anything else for the record, Ms. Shaw, on docket 23-00307?
No, Your Honor.
Mr. Blackman,
Nothing. thank
you're
you,
all
Judge.
set? All right. All right, Ms. Helmick, we'll see you on that date. And please keep in contact with your attorney, Fred Blackman,
Oh,
Let's-
definitely.
once you retain him.
As much as possible.
All right.
You got it.
I'd like to, thank you. That's all I need. We'll wait here, mister.
And then we're waiting for Mr. Bates. Is that right?
And David George.
And David George. In docket 22-00938. That is the people of the state of Michigan versus Chase Allen Bates. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Melanie Smith, Assistant Prosecuting Attorney on behalf of the people.
And good morning, Your Honor. Stephen Milks on behalf of Mr. Bates, who is present and seated to my right at this time.
And sir, you are Chase Allen Bates?
Yes, sir.
All right. This is the time set for a preliminary examination today. Ms. Smith, how are we proceeding?
Thank you, Your Honor. The people were prepared to proceed today. We did have victims ready here for testimony. It's my understanding the defense would like to request an adjournment and have his client waive 21 days to further review discovery. We did not have an objection to that request and waiver. I do have one request as it relates to a bond condition to address after the waiver.
All right. Mr. Milks, is that your understanding that there's going to request to adjourn and a waiver of the 21-day? I'm assuming it's for discovery purposes.
It is for discovery purposes, Your Honor, as well as further investigation. And just so the court is aware, we did receive the forensic interviews per stipulation. And Your Honor, regarding the proposed changes to bonds, Your Honor, we would stipulate to that, just.
All right, all right. So we'll do the bond conditions after we get the 21-day waiver out of the way. Mr. Milks, may I require your client of his waiver, the 21-day rule?
Yes, Your Honor, thank you.
Mr. Bates, you understand today that you have a right to a preliminary examination within 21 days of your date of arraignment. Do you understand that, sir?
Yes, sir.
And a preliminary examination is a probable cause hearing in which the people of the state of Michigan would have to prove by witnesses and evidence that a crime has been committed and the identity of the person who committed that crime. You, of course, are represented by Mr. Milks, and he would contest any charges and cross-examine any witnesses brought against you by the people. Do you understand that, sir?
Yes.
Do you understand you have a right to that prelim within 21 days? If you waive today, you won't be waiving your right to a prelim. You'll only be waiving your right to a prelim within that 21-day period. Is that your understanding?
Yes, sir.
All right. Is it your wish today to waive your right to a prelim within 21 days to allow your counsel to get more discovery so that they can have a zealous defense?
Yes, sir.
All right. I find the waiver of the 21-day to be knowing, voluntarily, and accurately made. Ms. Smith, you also waive your right to a prelim within 21 days?
I do, Your Honor.
All right. This is the adjournments for discovery purposes, and we will reset the date for prelim for,
March 17th at 1:30.
Your Honor, I'm going to be in Alabama that day at a required work training.
so that would be incredibly hard to be here from
It
Alabama.
would be quite hard, Your Honor.
So would you prefer I think the week earlier I'm out because I'm at some conference. so.
Or it would either be March 2nd in the afternoon or March 23rd at 8:30.
Is there any way we could do it 23rd in the afternoon? Just to be a real pain.
Sure.
Okay.
Mr. Milks, does that work? March 23rd in the afternoon?
Yes, Your Honor, that should be just fine.
How about 1:30?
Thank you so much for the court's flexibility.
And then as to the bond condition, Ms. Smith.
Thank you, Your Honor. There are 3 persons already that there's to be no contact with. I'm just requesting to add a 4th, who is a 4th victim in this matter. Her first name is Rosalie, Rosalee. Last name Scherer, Shearer.
I got it.
Shearer.
Okay, so Rosalie Scherer would be the fourth person on the no contact order,
That's correct, Your Honor.
on the
Thank
no
you.
contact. And Mr. Milks, my understanding is you do not have an objection to that 4th person.
No, there's no objection.
All right. Without objection, we'll add the 4th person of Rosalie Scheer to the bond condition of no contact. Anything else for the record, Ms. Smith, in docket 22-00938?
No, Your Honor. Thank you.
Anything, Mr. Milks?
No, thank you, sir.
All right, Mr. Bates, we'll see you here on March 23rd at 1:30. Okay, sir?
Thank you, Your Honor.
We're on the record in docket 22-03187. It's people of the state of Michigan versus Deshaun Alexander. For the parties, please introduce yourselves for the record.
Jessica Shaw, on behalf of the people.
Good morning, Your Honor. Attorney John Abbott representing Deshaun Alexander. He's standing to my right.
Sir, you are Deshaun Alexander?
Yes, sir.
All right, thank you. This is the time set for preliminary examination in the matter. Ms. Shaw, how are we proceeding today?
Your Honor, the victim has failed to appear in this matter and the people are unable to proceed without the victim.
Mr. Abbott?
Move to dismiss, Your Honor.
And just because I know we have a snow day today, have you had any contact with the victim in the case? She was subpoenaed to be here.
She was subpoenaed.
And you've not heard from her yesterday afternoon or this morning?
That's correct, Your Honor.
Okay. So, Mr. Alexander, the people are unable to proceed today with the preliminary examination. There's a dismissal without prejudice, which means they could bring back the case and reissue on it. But for our purposes today, the case is dismissed. All right, sir? All right. So for the record, I'm signing the nollie pros. Anything else for the record, Ms. Shaw?
No, Your Honor.
Anything, Mr. Abbott?
Could we get a copy of the Nelly?
You can. Yep. So I've got, it's in the file. I just signed it. I'll give it to Mr. Neves if he wants to give you a copy. He's also got to go get Mr. George. So somewhere in that time frame, he'll get you a copy, okay? I just Mr. Hess, how are you today?
I am well, Your Honor. How are you doing?
All right. I'm well today, a lot better than a lot, pretty good considering all the weather that's going on.
I know. It's nice to see everybody in one piece and warm.
Yes, it is. I agree. All right, let's go on. Mr. Riggins, this is on the record docket 23-00125. That's people of the state of Michigan versus Jeremy Riggins.
I am
well. The parties, please introduce themselves for the record.
Thank you, Your Honor. Jessica Shaw, on behalf of the people.
Thank you, Your Honor. I apologize. There was an echo there. Edward Hess, I'm appearing on behalf of Mr. Riggins. I unfortunately do not have information regarding Mr. Riggins's current whereabouts. I did receive an email this morning from Christopher Doan, the social worker at Sacred Heart. I'll just read the email verbatim. It says, Mr. Riggins is not at the facility. He was discharged as of this morning. I tried to call the phone number I have for Mr. Riggins. It appears to have been changed. It's some sort of commercial business now. So I'm following up with Mr. Doan to see if Mr. Riggins left any forwarding information, but I cannot apprise the court of his whereabouts. I did inform the prosecutor that Mr. Riggins, well, I told the prosecutor it was fine for her to not subpoena witnesses today because I thought it might be a waste of time. So I'm respectfully asking that if the court does enter a warrant for Mr. Riggins, that a hold be put on that warrant to allow me to try to get in touch with Mr. Riggins as best as I can. And then if we do reestablish contact, I would like to inform the court and the prosecution of that. But as of now, I can't tell the court where he is.
All right, Ms. Shaw, any response?
Your Honor, the people would request a bench warrant and we have no objection to a hold.
All right, I find that the defendant failed to appear for the preliminary examination. I will issue a bench warrant with a 48-hour hold, understanding weather conditions and everything that it just seems to make more sense. I will put a 48-hour hold on. It is an assaultive crime. It's 2 RNOs, but these last 2 days have been a little bit crazy weather-wise. So if you're able to get him in and keep the bench warrant off, you know that the court will make itself available. Other than that, if he goes past 48 hours and you can't find him, the bench warrant bond forfeiture will take place in 48 hours. All right, sir?
I understand. Thank you so much, Your Honor.
All right. Anything else on docket 23-00125, Ms. Shaw?
No, Your Honor.
Anything of Mr. Hess?
Nothing further. Thank you, Your Honor.
All right. You're all set. Thank you.
Take care.
She didn't. We're gonna bench warrant anybody today. on the record and docket 22-01903. And I'll go ahead and there's a 23-00326 that we can handle together or separately. It doesn't matter to the court. Will the parties please introduce themselves for the record?
Jessica Shaw, on behalf of the people.
Luke Goodrich from the Public Defender's Office here to represent Mr. George.
And sir, you are David George?
Yes, sir.
All right. This is the time set for preliminary examination today. Ms. Shaw, how are we proceeding?
Your Honor, with regard to docket 22-1903, the defendant will be pleading guilty to a reduced count or an added count of receiving and concealing stolen property, $200 to $1,000, and people would dismiss count 1.
$1,000. So that's an added count 2.
Yes, Your Honor.
Count 2 of receiving, concealing $200 to $1,000. Do you know the PAC code for that?
Yes, Your Honor. It's MCL 750.5354A.
5354A. And is that a 90-day, a 6-month, or a 1 year?
Oh, 1 year.
Okay. So 1 year and or
$2,000.
$2,000. And with a plea to that count 2, count 1 is to be dismissed.
Yes, Your Honor.
Is there any restitution on the matter?
Yes, Your Honor.
All right. So what's the restitution on file 22-01903? Or are you combining restitution as to the both files?
No, Your Honor.
Okay.
It's just on this
Okay.
file.
I only say that if we need to determine it by hearing, or if it's going to be a part of the sentencing.
It would be a part of the sentencing.
Okay. And we can let probation determine it. I want them to know what if we have it, what the restitution is.
Yes, Your Honor. I'm like, looking for it. I can just. One moment.
If you can't find it, it's okay.
Okay. We can determine
It's,
that.
it's in there, Your Honor, but yeah,
Okay.
we can, I'm sure be determined for sentencing.
All right, so Mr. Goodrich, is that your understanding? The defendant is going to plead guilty to receiving and concealing $200 to $1,000 pursuant to 750.5354 parents A. That's a 1 year and or $2,000. Restitution will be determined by sentencing with a plea to that amended added count 2, count 1 is to be dismissed.
That is correct.
All right. May I inquire your client of his advice of rights on his misdemeanor plea?
Yes, Your Honor.
So, sir, you understand that if you plead guilty today, you won't have a trial of any kind. And so I'm going to walk you through your trial rights here, okay?
Yes, sir.
You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond reasonable doubt that you are guilty. You have the right to have the witnesses against you appear at trial. You have the right to question those witnesses against you. You, of course, are represented by public defender, Mr. Goodrich, and he would cross-examine and contest any charges brought by the people in this file. Do you understand that, sir?
Yes, sir.
You have the right to have the court order any witnesses brought for your defense. You have the right to remain silent during the trial. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. All being, as long as you understand that if your plea is accepted, you'll give up the right or claim that it was not your decision to plead guilty or other than the discussions that have been made about the plea agreement. So is it your decision today to plead guilty today, sir?
Yes, sir.
Yeah, you understand we won't have a trial, so you won't be appealing any rights from the trial. You'll be pleading guilty because you are guilty. Is it your wish today to plead guilty to receiving, concealing over 200 but less than 1,000?
Yes, sir.
All right. I'm gonna have it. I don't have to do this, but I do it anyway. Raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Okay, I'm going to bring your attention back to the date of March 19th, 2022 at the offense location in the city of Lansing on Large Street. Were you on or about Large Street in the city of Lansing on March 19th, 2022?
Yes, I was.
All right. And why don't you tell me in count 2 for receiving and concealing over 200 but less than 1,000. What you did to make you guilty of that?
I placed some objects inside my car and took them to Freedland's scrap yard to be scrapped.
Okay, and you knew at the time that you took them that they weren't yours?
Yes, sir.
Okay, and the property that you took would be valued for our purposes under $1,000.
Yes, sir.
Okay, that was all in the city of Lansing on the date in question, March 19, 2022.
Yes, sir.
Any questions on the factual basis, Ms. Shaw?
No, Your Honor.
Anything, Mr. Goodrich?
Your Honor, I would just ask, did you know or should you have known that those objects were stolen that were placed in your vehicle?
Yes, sir.
Thank you. With that understanding, I find the guilty plea to RNC under the misdemeanor RNC, which is 200 to 1,000, to be knowing, voluntarily, and accurately made on the factual basis. We will set this. I'm assuming we're setting it for sentencing. So we'll set for sentencing, and I'll refer to you to probation. So probation will be in contact with you. What they'll do is ask you a lot of questions. They'll develop a report for me. So at sentencing, I'll have something to look at what options we have, okay? Okay, so refer to probation. They'll be in contact with you on a sentencing date of
April 25th at 2:30.
April 25th at 2:30. And restitution will be determined by then, all right, after they talk to you and look at the facts of the case. All right, with that understanding, is there anything else on record 22-01903, Ms. Shaw?
No, Your Honor.
Anything, Mr. Goodrich?
No, Your Honor.
All right, that's all for the record in that file. And then as to docket 23-00326, parties have already placed their appearances on the record. Ms. Shaw, this is time set for preliminary examination. How are we proceeding?
Your Honor, the victim has failed to appear in this matter and the people are unable to proceed without the victim.
All right.
Your Honor, with that being the case, the defense would move to have this matter dismissed at this time.
Okay, so defense moves. Let's go. I assume it's the last case that you've not had any, we've had snowy weather these last couple of days. You've not had any contact with the victim. They were subpoenaed to be here and you've not had any contact yesterday or today with them.
Not yesterday or today. We did inform her of the time. We also informed her of the delay.
All right.
However, she is not.
Okay. With that understanding, the motion to dismiss is granted without prejudice, okay? Which means that the people may proceed on the same allegation in the future. They can't proceed today. They may refile, but for our purposes today, the case is dismissed. All right, sir?
Yes, sir.
Okay. And I will sign the nollie pros to that effect. Anything else for the record in docket 23-00326, Ms. Shaw?
No, Your Honor.
Anything, Mr. Goodrich?
No, Your Honor, I just do want to bring to the court's attention, though, that Mr. George will be released on bond today as he was being held on the case being dismissed.
Okay.
As far as probation on the other file.
All right, so that's good to know. You should report to probation if you're out within 48 hours. So let's give you to make sure that you've got some time. It's Thursday. Let's give you Monday by 4, okay?
Yes, sir.
Monday by 4, let's refer to get you to probation to keep that moving. If you don't, they're just gonna issue a bench warrant for you and we'll be right back where we are. So just make sure you get to them by 4 so you can answer any questions on the date on the previous file, okay?
Yes, sir.
All right. Thank you for that. Thank you for that, Mr. Goodrich. Anything else for the record in 23-00326, Mr. Goodrich?
No, Your Honor.
All right, Mr. George, we'll see you on the sentencing date, okay?
Thank you.
Mr. George, is this phone number correct?
Okay.